Mr. Hudson, it's all yours.
Good afternoon, everybody. Thank you, Mr. Lu, President of GAPS, and Danny for those very kind words of introduction. Now, this afternoon, we're here to discuss the role of a land survey in land titling by adverse possession. So just to give you a quick overview of what the presentation comprises of, we will basically the background, why we are here this afternoon, discuss this very pointed issue, the objectives of the presentation, and then we will move on to define key terms. We will then turn to look at the laws concerning adverse possession and land survey, followed by private state government land and the application of the laws for prescriptive title to those categories of land, leasehold and adverse possession, easements and adverse possession. And then we will move into the gravamen of our discussion this afternoon, which concerns the duties of a land surveyor when executing a survey, the title by adverse possession, the title by prescription adverse possession, some of the challenges and some of our recommendations. And then very importantly, we look at some of the case studies concerning some of the leading cases and the cadastral plans and occupation plans that were submitted in support of the claim, the title prescription by adverse possession. So without any delay, I know we had a late start and we have over 35 slides to go through. So the background is generally that distant parties and members of the public, including officers of the court and clients more particularly, are unaware of the role and duties of a surveyor during the performance and execution of a survey for prescriptive title by adverse possession. Now, this has basically, and basically I say this because I've been in the room a number of times with even such a person as the CEO of Land and Surveyors, young attorneys, senior government functionaries, who basically were convinced that the surveyors were either intentionally or inadvertently misleading the court and resulting in defective titles being issued. So more recently, I've been at a lunch, and a senior attorney, senior counsel, raised the same issue: what really the role of a land surveyor? And he was very convinced that the land surveyor was basically misleading the court and causing defective titles to be issued. And really is the gravamen of our discussion this afternoon. And what may seem to be a slight distinction is really an important distinction that must be conveyed and articulated clearly by surveyors to the general public and to other parties participating in the land titling through adverse possession process. Now, this has led to many occurrences of obstruction to surveys, where the parties actually believe, because of custom, because of the information that they are in receipt of, that a surveyor places a pall or a boundary mark, he actually determines the ownership of that land. And that is the issue that we need to focus on this afternoon, and to try to set out clearly the roles of the different players in the land titling process. There has been allegation of surveyors being part of deceit or subterfuge and misconduct, which, if it is substantiated, if we are in receipt of the concrete information, the surveyor is on oath to be honest and to be ethical. And if we are in receipt of that information at the level of the commissioner and the board of land surveyors, recommendations can be made for the surveyor certificate to be canceled or suspended. And so there's also a need for us to, as a fraternity, articulate our role clearly to the public and all the other parties involved in the land titling process. So that basically is a background to why we're here this afternoon discussing this issue. The aims of this presentation is to analyze performing and executing a class survey for prescriptive title through adverse possession. We will review the statutory requirements for each step and discuss best practices. What I've tried to do in this presentation is to merge step 2 and step 3. We will be reviewing the statutory requirements and discussing best practices. And then we will move on to examine and discuss title plan by adverse possession and its application to different categories of land, such as easements, leasehold, private lands, government and state land. And of particular interest is private. Some of the allegations of subterfuge and deceit are leveled by persons who hold private land, and a lot of those individuals reside outside of Guyana. And when they come home, find that their right to land has been superseded by claims of adverse possession. So quickly, if you permit me, because in interest of time, to just go quickly the definition of the terms. And this would lead us into the governmental discussion this afternoon. Prescription is basically a common law right to land acquired by continuous user for a time beyond memory. The cutoff time is 1189, and that is as far back as legal memory is required in England. But different jurisdictions, such as Guyana, has enacted legislation to set out was the limitation period. So for Guyana, 12 years for private land, and before Act Number 6 of 2011, was 30 years for state and government land. Right? Adverse possession is basically taken when a squatter, trespasser, former lessee, or former licensee outs or deprives or denies the holder of a paper title to land, or anyone acting to him of possession. So adverse possession is basically taking possession from the rightful owner. And a person who does so for a undisturbed period of 12 years has a right to approach the court to formalize his possessory title. The definition of land surveying was basically taken from evidence and procedure for land surveying. So evidence procedure for cadastral boundary surveys, right? And it means the performance or practice of the art and science of making measurements in the horizontal and vertical planes, and to establish, and the use of special knowledge, training, education, and experience to establish, relocate land boundaries, subdivide land, determine land areas, prepare legal description of land, maps, and plans. All right, so in this presentation, you will hear me talking about the technical aspect and what distinguishes a professional land surveyor from a technician who obviously can establish horizontal and vertical measurements and so on and bring in the information. But there is a distinction between a professional land surveyor, a sworn land surveyor, and a technician. So I will be elaborating that point. Now, very important for our discussion this afternoon is right to adverse possession, because a person who claims a right to adverse possession claims it under a law, and that is the law that authorizes the surveyor to enter into any contract and to commence the process of permanent executing a survey on that person's behalf, right? So in all of the leading cases, possessory rights that crystallize at the end of the statutory limitation period is adverse possession. So it operates to always bar the owner of the land under paper title or anyone claiming through him from bringing an action to recover possession of the land. And it gives the possessor the lawful right to employ a sworn land surveyor to perform and execute a survey of the occupation of that land. Next slide, Danny. So in terms of the law touching on concerning adverse possession of land, we obviously have the Title to Land Prescription and Limitation Act, Chapter 602, which requires sole and undisturbed possession. So this legislation has basically 4 arms that must be satisfied. You must be in sole and undisturbed possession, user, or enjoyment for not less than 12 years for private land, of course. Even by force. This was elucidated in the case of the AG of Sad versus the AG 2008. The Roman Dutch acronym of NEC-V, nec cum, nec precario. Well, the NEC-V does not apply because of the legislation. The second arm, it must be openly enjoyed without the consent or agreement expressly made or given for that purpose, with fraud and satisfaction of the court. And this is very important because it must be to the satisfaction of the court. And a lot of the violence that occurs when a surveyor attempts to define boundary parcel of land or to gather the information for the court occurs because the person who has that they right to the land may be affected by the execution of a survey, is not aware that the surveyor does not determine ownership. The surveyor does not determine ownership. The surveyor will define the boundary of a parcel of land and the court will determine ownership, right? So that's something that we will expound upon clearly in the presentation when it comes to the role of the land surveyor. Of course, the Land Surveyors Act, Chapter 9701, which basically says that where a surveyor intends to survey land that is in dispute or to survey land for any purpose, he shall give at least 15 days notice in writing. Most importantly is to the adjacent landowner. So this act, which was done in 1891, was passed in 1891 and amended as late as 1987, requires notice to the adjacent owner and not to the owner or holder of the paper title, right? And we will basically expose this with the role of the attorney under the declaration of title rules, whereby the attorney is required within a certain period to give notice to the owner of the paper title. And we will also juxtapose this with the requirements under the proposed bill of 2010. So the court basically requires postage by registered mail, and based on the Interpretation and General Clause Act, where notice is required by post, it shall be the day of post, it shall not be counted in the 15 days. And this is very important for surveyors. The day that you issue the notice or you send the note, it should not be counted in the 15 days. Next slide, Danny. And then we move on to the High Court Declaration of Title Rules, which provides that a petition setting out the material facts, particulars of the property, its nature and extent. Basically, in the words of surveyor, the applicant's true and connection to the land, along with a plan. Now, the plan is not a strict precondition or a strict requirement because the court under the act or under these rules could dispense with the application, with the requirement of a plan on the application of the petition. And very importantly, I have to agree with the assessment made by the Women's Lawyers Association publication in 2022, where occupation plan is preferred over a cadastral plan. Because a cadastral plan, as surveyors know it, is a final plan. And we can't logically go to the court final plan. And the court has the jurisdiction to determine ownership of land. So the court can look at the final plan and dispense with it and only grant as much of the land that is beneficially occupied by the petitioner. So we have these registry rules, the section 22, which requires certified plan, the Land Registry Act 3851, which deals with the requirements for plan, 106 and 107, which deals with the requirements for adverse possession. And the leading case, Tulsi Prasad and the AG. And this Tulsi Prasad and the AG basically is a case that I commend for the reading of all surveyors, basically, because this enunciates a number of fundamental principles, such as the Takan principle, where a person could be in occupation, sole and undisturbed possession for 2 years, and then sell or transfer that right by agreement to another person who is there for 10 years, and the 10 and 12 could come together to qualify for possessory title. So the Takan principle was enunciated in this case, or restated in this case. The fact that the state can be an adversary was also enunciated in this case. And very importantly, under the principle of mistaken belief. So a person who has been in the mistaken belief that he is a legal title holder on a paper title, time begins to run in his favor if he is not actually the owner on that paper title. So this case brings out that principle as well. And the fact that the nec v in the Latin acronym nec v, nec cam, nec precario does not apply. So you can, by force, be in adverse possession against the paper title holder. I included the UN Declaration on the Rights of the Indigenous People 1948, which is similar basically to possessory title if they've been in traditional occupation and use of land. The other important piece of law concerning adverse possession in land surveying is rule and guidance for land surveyors. Now, all lands were alienated from the stock of state lands. So all lands that is now held privately came out of the stock of state lands. And the principles set down for the alienation of that land is the rule and guidance for surveys. And basically, it provides that any survey within 2 miles of existing original survey should be connected to the original survey. And that is another point that we will spend some time on this afternoon to bring out the importance of tying the cadastral grade base maps. And obviously the question of from the deprivation of property under Article 142 of the Constitution, which is subject to the Limitation Act. So although your right to property is protected, it is subject to the Limitation Act under the same section 142(2)(a)(4) of the Constitution of Guyana. So what a trespasser who've been in sole and undisturbed possession, use, or enjoyment of your property can trump you if satisfies the court in that regard. Next, so in terms of private government land, state land, and their definition, private land is any land held under some form of paper title and vests full and absolute ownership to the grantee. Example, an absolute grant, a transport, a certificate of title, a certificate of ownership, or a lease. Government lands, on the other hand, are lands held privately by the state under some form of paper title, such as an absolute grant, a transport, or a certificate of title. And this is within the meaning of the Land Department Act. And now the quasi-government land is very important for land surveys as well as attorneys, because the amendment to Section 3 of the Title to Land Prescription and Limitation brings together all lands, quasi-government lands, and protects it under that provision. So there are lands held by any state corporation, any state company, any state agency or entity in which the government has a controlling interest. State lands, on the other hand, are all lands that are all unalienated lands within the boundaries of Guyana, which is vested in and to the land by the prerogative of the state. And therefore, state lands does not have a formal paper title evidencing the state's ownership. Right? It's just held on the patrimony and the prerogative of the state. So private lands and adverse possession, we know that can be acquired by 12 years, sole and store possession continuously. Government, quasi-government land and state lands may be acquired by prescription through adverse possession for 30 years if the possessory rights crystallized before 2011. And this was enunciated in the very, very important case for land surveyors of Godfrey West versus Nissil 2020. All right, this is the first time I believe the Court of Guyana has interrogated the amendment to Section 3. And the court basically said that quasi-government and government land, as well as state lands, may be acquired if possessory rights crystallized before the pass in 2011 that prohibits new applications from being considered for government, state, and quasi-government land. Right? So quasi-government land, and state land shall not be acquired by prescription through adverse possession after 2011, after the passage of that act. And that is clearly stated in the end to the Title to Land Prescription Limitation Act. Next slide, Danny. In terms of leasehold and adverse possession, well, a lease is basically absolute legal interest. It grants exclusive possession to land for a term of years. It is a right in rem. The legal rights to the land moves importantly from the lessor to the lessee. And a lot of surveyors cannot wrap their mind around this concept, right? A lot of people practicing in the profession of land surveying does not realize that the legal rights move from the landlord to the lessee. So as long as the lessee is not doing some act that basically puts this to the land, the lessor has no legal authority to prevent a squatter from going on those lands, right? So it creates an estate in land. And an estate basically speaks to the whole long. An estate speaks to the whole long of a legal interest the individual has. So if it's a fee simple estate in perpetuity. If it's a 99 estate, it's for 99 years. A 50-year lease is 50 years. 20 years, that is your estate in land. And that's another terminology that surveyors don't really mind around. Estate speaks to how long, 10 years to the type of title that you hold for the land. But most importantly, a lease is absolute legal interest for the term of years. And legal ownership moves to the lessee. And so adverse possession against a lessee will operate if the land, if the tenant's right is basically trumped by a squatter. So we're saying here, quoting from Professor Codolini and Professor Uso, if the landlord leases land to a tenant for 99 years, and 10 years later, if a squatter outs the tenant and remains in occupation for 12 years without any action being brought against the tenant, being brought by the tenant, who's the legal owner, the squatter has indefeasible rights against the tenant, but not against the landlord, right? So the tenant has 12 years from the dispossession to sue, after which his title is barred, mirroring the Title to Land Limitation and Prescription Act. And on the other hand, after 12 years of expiry of the lease, the lessee has possession of the land, right? So moving on to the next slide, Danny. What is an easement? Easements and adverse possession. This is very, very important, I think. An easement is a right to use land owned by another person, the servient tenement, for the benefit of another plot of land, the dominant tenement. So the servient tenant is most time the person, in our terms, living in front, and the dominant tenement living at the back. So right away is an easement, pass and repass, ingress and egress to the dominant tenement. So a right-of-way in Guyana is a positive easement or real servitude, and it does not bind the successive owner of dominant tenement. And so the custom, particularly in Georgetown, where a dominant tenant will fence off the right-of-way, or the surveying tenant will fence themselves out of the use of the right-of-way. If the dominant tenement changes hands, well then that covenant does not bind the new owner because it's a positive covenant, and the presumption is positive covenants do not run with the land as negative covenants do. More importantly, at point 2, if the adverse possessor has no privity of contract and therefore will acquire the prescriptive easement after 12 years of sole possessor, user, or joint. And Section 2 of the High Court Declaration of Title Rules define property to mean land or any easement or any profit apprendi or any right connected with the land. So after 12 years of sole and undisturbed user or enjoyment of a right-of-way by an adverse possessor, he can approach the court under Section 2 of the High Court Rules, establish his right to that easement or his right to that land. And this is very important in case where the easement enlarges, because on the normal common law principles, you cannot enlarge an easement. If an easement is 6 feet, it remains 6 feet. But if an adverse possessor enlarged that easement and has been using it for solely and undisturbed and has fenced it out either by force or the acquiescence of the surveying tenement, well then he's under Section 2 of the title to the limitation under the Declaration of Title Rules to approach the court for declaration of title. And so, colleagues, that is the proprietary information for what is the gravamen of our presentation today regarding the duties of a land surveyor. Right? And so we've divided these duties into 5 easily recognizable activities, which are the initial contact with the client, reconnaissance and research, notice of intended survey, the performance of the field work, and the execution and preparation of the plan and report. So the initial contact with the client will basically, for prescriptive rights surveys, will be from attorney and an agent or some former client, or it might be somebody walking into your office for advice on how to proceed with certain matter. Most surveyors, next slide, most surveyors will basically enter into an oral agreement. And here is where we'll make some of the current practice and the best practices going forward, right? They would enter into an oral agreement without no form of written contract. And we're saying here that particularly for surveyors, for surveyors, prescriptive title adverse possession, it is advisable that the surveyor execute a written contract. And secondly, obtain a retainer from your client, because whereas a retainer is mandatory for public land surveys such as state lands and government land, you must provide a retainer to say that you've been retained by X and Y client. It is not a requirement under the Land Survey Act, but it is practice regarding surveys for prescriptive title. Right? You might issue a notice of intended survey and you inform the client that you'll be traversing, but you can't expect the client to pay a surveyor or to be there for 3-4 days while you orient yourself and traverse and find your original marks and so on. So having that retainer in your possession is a good practice going forward. And on the next slide, we deal with the fees for consultation, particularly for surveyors, and we encourage us to establish your offices because of the price of real estate. Now you need a proper office. You can't continue to operate out of your briefcase and so on. And for prescriptive rights surveys, you must satisfy yourself that the claim is not a bare claim, so to speak. And so you need to consult with the client. They need to pay a consultation fee. And in terms of the payment, this is what we've learned 20 years ago. The payment in a contract for survey should be 3 parts. After the services are accepted, before the field work commences on the day of appointed, and on delivery of the plan. You will see how this will tie into the best practices going forward. And we know some surveyors will collect 50%, 75%. They will have these jobs rolling over rolling. And what we've tried to fix, we've tried to rectify issue in the proposal and survey bill by requiring that after 30 days of execution of the survey, you must deliver that survey plan, right? So that is a best practice I'm recommending going forward. And the big issue is research and reconnaissance, right? Research and reconnaissance. For prescriptive right survey, it is advisable surveyor visit the site, basically to acquaint or herself with the location. But with the aid of the technology now, you can from your office use Google Earth or one of the other remote apps and go to the location, discuss location with your clients, have our appreciation for the layout of the land, and basically be able to do efficient research. In the olden days, because the client is coming to you with no paper title, it's difficult to orient yourself for, particularly for a young surveyor that is not practicing in that area. All right, so we included it here, the site visit. We're saying that you must satisfy a beer claim, because this is where some of the allegations of subterfuge and deceit comes in, where a surveyor may probably take on a job that the claim is not really founded in law, right? So you're not obligated as a professional to accept a job based on a beer claim. And this is what I was discussing with my colleagues earlier. This is you from a technician. You're a sworn land surveyor, professional surveyor, and you must say yourself that what you're doing is ethical going forward. And so the site visit allows you to obtain the name and poll addresses of the adjoiners, and basically to research the original plan or other contemporary plan from which you could corroborate your location. A lot of times these plans are done in the 1800s with no line plans, and you won't be able to find the original marks, and therefore you would rely on some contemporary plans going forward decade by decade that traces you back to the original plan. And this is where the rule and guidance for surveyors, as I will explain later, comes in very important. And we cannot derogate from that principle, maintaining the original principles in the rules and guidance for surveyors. And number 5, this issue is an issue that has been of much contention in the land surveying fraternity, whether or not a surveyor is required to research the titular ownership of the areas to be surveyed. And obviously the answer is yes. And this is another point will distinguish the technician from the sworn land surveyor or professional land surveyor, because the better you can go back in time and research the title ownership and assist with that information, the more professional, and you will distinguish yourself from other professionals and individuals practicing in the fields, right? So the conclusion is, although this is not a statutory requirement, a good practice, but we will distinguish how this research should be contained in a cadastral plan, the title by presidential adverse possession in some later slides. So next slide, Danny. So the notice of intended survey under the Land Surveyors Act, Chapter 97 or RAN, provides that the land surveyor who intends to execute a survey, he or she shall give at least 15 years notice in writing to the owner or occupier of the adjacent of land. And that is the statutory requirement. But here again, to be a professional, you must go further and to satisfy the administrative rules and principles and to satisfy the good governance procedures of effective notice. As a professional, you need to distinguish yourself by giving the paper title, holder of the paper title, notice of intention, even if that person is given constructive notice to somebody in Guyana who made him, such as a person who is an old person in the village, a person that is a farmer headmaster or something like that, contact of the paper title and make them aware, because you don't want to be party to any incidents or allegations of subterfuge, right? So registered posts is a requirement also for adverse possession surveys with title by adverse possession, because the court, if you're called to give evidence where it is disputed whether or not notice was served, the slip of registered post is the return slip of registered post is conclusive evidence that you have complied with maximum requirement of constructed or actual notice on the Interpretation and General Classes Act of Guyana. And so a good practice is to copy the notices to public places such as the police station, health center, and the village shops or rum shops or popular places visited by many people in the community. And a point to note is that the Land Surveyors Bill of 2010, which was probably revised in 2016 or 17, provides for more effective notice that the surveyor now will be required by statute to give notice of the paper title, the actual notice or constructive notice. So moving on to the performance and execution of the field work. The surveyor or the technician may do preliminary traversing. This is a part of the requirement on notice under the Land Surveyors Act. So he may do traversing before the appointed day to ascertain the location of the land in relation to monuments found and their position. But as good practice, we want to encourage that this aspect of the field work should not commence before reasonable notice has been delivered to the parties interested, right? And the surveyor should avoid entering into closed properties before the appointed day. So although you give them permission under the Land Surveyors Act 9701 to commence traversing, I don't believe that traversing within a closed property is reasonable under the act, right? You can do traversing to original marks, to corroborate marks and so on, to orient yourself, but leave the actual traversing in the premises for the appointed day. So the surveyor must also obtain the names and address, postal address of all those who attended. And very, very importantly, the client or his duly constituted personal representative must be present. Most survey plans for claims adverse possession, the surveyors are saying that the client was not present and nobody objected. The client must be present to point out to you on the appointed day the area that he's claiming, the fixtures and the chattels and other development of the lands that he is claiming that he has acquired this possessory rights to. And so that's something that we must fix going forward. Well, for a standard survey, you must, of course, place your boundary marks. You must pick up bearings and distance and so on. And that must be done in the presence of a client, anyone who attends the survey. You have to obtain the names, address of the adjoiners. You place your permanent marks. Well, this is more formal cadastral stuff. Place the permanent marks, obtain a true bearing and distances. You must survey in relation to the boundaries claimed. This is very important, and this is another point that will distinguish you from a technician. If you are a sworn land surveyor and you execute a survey for a title to land by adverse possession, title to land by prescription through adverse possession, You must be able to identify all the fixtures to the land, all the development made to the land, such as the house, the type of house, whether concrete, wooden, if the land is enclosed or not, the type of fence, the drains, the dams, any embankment. For cultivation land, the area, whether it's cash crop and how long it's been planted, permanent crops, in the opinion of the surveyor, the age of those permanent crops, and of course the approximate acreage on the cultivation. And you must elaborate that in the report to distinguish yourself as a professional rather than a mere technician who could just turn angles and pick up distances and put it on a plan. And very, very importantly, and I think this is a point the land survey bill and regulations should address, is objection to surveys. A lot of persons are unaware that any objection that you make as a person attending the survey shall be recorded on the cadastral plan. Whether it's an oral or written objection, it must be recorded in the cadastral plan because the surveyor is the gatherer of the information for his client and as well as for the courts. Right? So if persons attending a survey who intends to object to a survey knows that any objection made either orally must be recorded, and then they can go further and submit written objections to the survey, to the Commission on Lands and Surveys, who shall ensure that those objections are on the plan, which informs anyone using the platform as to the persons that should be contacted with an interest in this land. Right? And I believe if that is included in the notice of intended survey form going forward, then clients will be more aware and will not be basically objecting or trying to prevent a surveyor from executing his jobs, right? So if you continue to do the survey, you must state why done, or if you stop the survey, you must explain to your client on what basis you decided not to go for a survey. And that is a statutory requirement, which I think is valuable to maintain forward in any amendment to the Land Surveys Act. So now, colleagues, we're looking at some of we're looking at the current standard that obtains for a cadastral survey, right? So the current standard that obtains for a cadastral survey is that the surveyor will say who we serve notice on, but there's no, this is of no use to the attorney. This is of no use to the court because there's no address for them to contact anybody. It's very easy for a surveyor to obtain the address and to include it in the notice. And in the example that we will share later on what is an appropriate standard for a cadastral survey, some information will be included, right? Of notice that the survey, any notice where the persons cannot be found at their home, the parties interested cannot be found at home or by registered post or ordinary post, the notice should be placed on a conspicuous location of the adjacent property. And most surveyors will say that they put the notice on the property to be surveyed. And that is a total error, right? It should be on the adjacent property so that the adjoiners will be aware that a survey is about to be executed for title by prescription to adverse possession. And if you look at minute 3, it says that Hubert Wilfield attended the survey. No objection was made. It does not tell you who he was, who he represented. But at minute 5, it says that my client, Natasha Gravesandi, claimed to be in undisturbed possession, but she nowhere in attendance of the survey. And this is one of the issues brought out by the senior counsel in our discussion, right? This seems to be something amiss. And this is the standard for cadastral surveying. This is why everybody repeats. Most surveyors repeat, not everybody, but most surveyors repeat this on the plan. No one attended, but the client still claimed to be in adverse possession. How it is that you're able to corroborate anything and to have the client point out his occupation to you on the day and to receive objections, right? So at slide number 23, Danny, slide 23. Right. So this is what we propose that the new surveyor's report and memorandum should look at. So notice of intended survey was served for a person. So if you're doing a survey in the city, is the town clerk, city councils of Georgetown, you give their address. This would assist with postage of notices by the attorneys. If Patrick Ford is at Fardan, you give his address. Satish Prasad is at Lot 43, you give his address. Ramit Ramjiwan, he lives at Lot 10, that's his postal address, you give it. And if all the parties concerned cannot be found, then you post up conspicuous notes on the perimeter of the premise to be surveyed. This is the requirement on the current law, but we will go further to suggest that notice should be placed on the land to be surveyed as well. Next slide, Danny. In terms of execution of the survey, you will state the date that the survey was commenced and completed, who attended the survey on whose behalf, and if it's a survey for title by prescription through adverse possession, the person who is claiming must be in attendance. Next slide, Danny. So you will state your reference plan and diagrams used, and very importantly, you must state the original plan, the oral call of the land that you're in. And very importantly, now this is very into the distinction between positively stating that this portion of land is held by a particular person, or stating the authority of the survey to execute the cadastral survey. A lot of surveyors, in my view, have made the mistake of trying to positively determine the ownership of the land, and a surveyor is not the authority on ownership of land, right? So a surveyor should state on what authority he is performing an executing cadastral survey, and it must be by some law, or it must be under some form of the title. And so if a person, in your view, has possessory title portion in land and you take on a job, the title to land through adverse possession, right? You have to state the law under which you're operating. So your authority to survey wouldn't be that, as if you go back to the previous example sometime, you will see the surveyor says that this land is held on the transport number, That is not he is not competent to determine ownership of land, right? He operates under some law, under some claim that gives him permission and the authority to do the survey, or for document is presented, right? So the example here is that claim to be in stone and area survey for more than 12 years, and has requested the survey to facilitate an application for prescription through adverse possession by virtue of the Title to Land Prescription Limitation Act, or the Declaration of Title Rules under Chapter 302 of the Laws of Canada. And your research, and I will bring out this point very clearly on the distinction between the role of a surveyor and the role of an attorney and the court. Your research can lead you to conclude that this is the paper title that you're operating under, but you cannot definitively say that lot 39 is held on the transport number by XY person. Research might lead you to conclude that lot number 39 Dell Street is held by Ramit Ramjiran by transport number 10 of 1987. But that transport could be defeated by a possessory right by some other person with a senior right to the land. And that jurisdiction lies with the court. And to facilitate good title, the attorney has a role to play, which we will discuss later. And so in other aspects of surveys, you can say, my research revealed title ownership of lot 39 Dell Street, Plantation, Campbellville, is held under tribe transport number 21 of 1930 by whoever. That is your research. So you make a statement that this portion of land is held because you're not determining ownership of land. You're operating under law or under paper title. So in the next slide, we move on to the purpose of the survey, which is standard. And the purpose of the survey for adverse claim is to show occupation of the portion of land by the person, and is going to put their ID number. And in other aspects of surveying, right, you might want to say that the purpose of the survey is to retrace and monument the boundaries of the portion of land. Under wherever document the person purports to be in control or possession of this land. So it might be a transport, it might be the executor, executrix, or some other paper title, right? So that's the purpose of the survey. And the occupation of the plot of land. This is what distinguishes you from an ordinary technician. A foreign land surveyor must be able to, in his or her own professional, that the portion is held, it is actually occupied by wooden, two-flat building, concrete building, the dimensions of the building, the situation of land. If it is agricultural land, how much coconut trees the person have, the permanent crops, the approximate age, you must state it in your opinion. This is what distinguishes you from an ordinary technician. Anybody could turn an angle. If you want to distinguish yourself as a professional land surveyor, you have to be able to provide this evidence to court because you're the primary obtainer of the evidence for the court and for your client, right? So you state the drains, if it's earthen drains, concrete drains, and so on. The land is fenced, if it's wallable, concrete fence, and so on. All of the fixtures and chattels that you find on the land, and you must say that these developments were played by your client, and if there's any opposition to it, you must state that so that the user of this plan, the court, the opposer, is aware of all of the details concerning the occupation of that portion of the land. So, Danny, moving on to some of the challenges on slide number 27. We have isolated surveys and the absence of a compiled georeference plan. I mean, back in the days when the surveys were few and apart, it was practical to basically plot them in the drawing office using conventional methods. But without a cadastral grade types, the existing surveys, the original, which are the original to many contemporary transports. So what we have now is a situation where the volume work is so much that we can't do it conventionally, right? And the quality of work has diminished because we have lots of transports, certificate of title that refers to plans that are not of cadastral grade. We will spend a few moments elucidating this point more clearly later on in the presentation, right? And so it will be very costly and difficult to reconcile them in a cadastral grade index map in the future. 20 years ago, when TA Oral Farmer Commissioner of Land Surveys made a presentation on this issue, he was of the view, and I agree with him, it's very easy to put together a parcel identification map, right? Parcel identification map. All you need is the center coordinate portion of land. If the land is 100 feet in facade and is represented at 60 or 80, that will come out in the cadastral grade, but it will guide the surveyors in order to obtain all the relevant information that touches and concerning the parcel of land. And 20 years has elapsed and we've not made much progress in putting together a parcel identification map, much less moving towards a more arduous and technical issue of putting together a cadastral grade map with cadastral grade ties, right? Which will basically enrich the research and the profession as a whole. The other issue is overlapping boundaries and overlapping titles, which prevails because of issue number one, right? Because it's difficult. The court basically is shooting in the dark with a cadastral plan in front of them if they can't see it in relation to other boundaries, right? And if lands and surveys itself can't see it in relation to other cadastral boundaries. So everybody is shooting in the dark. Of course, we have the issue of missing deeds and unclear responsibility, right? There's lots of missing deeds in the deeds registry, some in the archives which were before 1925 and has been put away after 1925, torn out, mutilated, and all of these issues, right? And I've seen prescriptive transports that have been issued against no title deed, right? Every transport, according to the deeds registry rules made under the Deeds Registry Act 501, sorry, must be referenced or backed by another transport. And we've had the famous case of best claim to the extension of New Road Wiedenhoop, where the court actually issued his transport for the first Wiedenhoop on a transport for the second Wiedenhoop, right? And that is defective title. It's a clear case of defective title, right? Because of some of the issues concerning the map of these tracts of land. The issue of entrance custom and practice, I have stated here, and it's subject to challenge, but due to the cumbersome and technical and difficult nature of dealing with property in the deed system, the practice is very lucrative, and therefore change has been and will be resisted. A lot of people will be affected by the deficiencies of the deed registry system, but you don't see the energy and you don't see the need and the push from the professionals practicing in this area to change the registry system, which provides weak title to a more secure and indefeasible type of title under the land registry system. And so some of the recommendations going forward is that private surveys and surveys for prescription should include coordinates, which basically would give you a quick guide to the property, and it could be used on Google for the courts, for lands and surveys, and it should be tied by bearings and distance to the original survey, right? This is one of the areas that most of the contemporary plans now are not tied by bearings and distance to the original survey, and it derogates from the responsibility, the primary objective of the rules and guidance for surveyors, which all cadastral surveys should be tied at the cadastral grade so that retracing the boundaries is a matter of technical accuracy. So we say coordinates can be used as a quick parcel situation identification method to determine whether a site visit is useful. So a survey for adverse possession could be armed with Google Pro. They can be given a 12-digit Eastings Northings to punch in, and they will be able to go out and view the land, go back in years to corroborate any claim. You could go back up to 1970. Google Earth has images, and you could come forward. That would be a useful initiative. And at bullet number 2, mirror in the land registry system, we should, for the deed registry system, introduce preliminary awards, which is based on a sketch plan. And I saw this point elaborated by the Women's Lawyers Association. The court really prefers a sketch plan to be presented to them with a claim for adverse possession, because ultimately it's the court must decide whether or not the client satisfied the requirements for a grant of. And if you submit a final plan, well then it's basically preempting the decision of the court. So we're saying a surveyor report should be requested, which could be paid for by the applicant, and then the commission would assign resources to plot the original plan in the area to eliminate any overlap, and then to approve the preparation of the final plan. So this is basically a suggested improvement to the deed registry system. And at number 3, cross-referencing. Both the deed registry and the land registry is lacking in this regard, because a person could easily pick up a transport and get a plan number and come and within minutes get the original plan call for the land. But if the transport number, if the plan number is not there at the registry in the title document, it's not there in the land registry in the title document, well then it makes it difficult, and then the surveyor has spent hours now assisting the client. It makes everything more expensive. And in the land registry, we had some success way back in years where we had convinced them to include the plan number, but now because it's not a statutory requirement, they've refused to include the plan numbers in certificate of title, which is time consuming even for a surveyor to find the correct reference plan. And all of that can be avoided just by including the Lands and Surveys plan number. And a point to note is that in the Interpretation and General Clauses Act, it provides that wherever forms are provided in any written law, slight deviation thereof, not intended to mislead, shall not invalidate them. So you can't rely on a form that says that we don't require plan number, we just require zone, block, and parcel, to refuse to include a critical information as the original call for portion of land. This is weighing millions of dollars when you put together of research, and eventually the bill goes to the client in the system. So at slide number 29, we recommended an amendment to the Land Registry Act to appoint a commissioner to every block declared as a registration and to treat it as a registration, so that every parcel of land shall be settled within the land registration period, which period should be clearly defined. Right? As it obtains now, all of the land registry areas are incomplete, and no sitting judge of land court has ever perfected title to each parcel of land in a block as envisaged, this is the wrong word, as envisaged by the Land Registry Act, right? The judge in the case of the land court judge in the decided case of Low Achieve 2002 made this point very, very clear, right? And we will spend a minute or two looking at that. And so finally, we should systematically convert the land registration. I think from 1969, when the Land Registry Act was passed, it was very clear that the land registration system should have superseded the deed registry system. And unfortunately, in some areas, even areas declared as land registry areas, we still have transports being issued, right? So with the aid of the available technology, special purpose general boundaries map, supplemented by field measurements, can be prepared and used to issue cheap and indefeasible title in high value built up areas, right? So one of the issues raised by one of the authors that was peeved with the deed registry system and how easily your title can be defeated by adverse possessor, that would be protected if all of those areas were converted to land registration, because once the holder of a paid title or anybody claiming through him puts in an objection, the judge is mandated to refuse the application. It's not in the discretion of the judge to determine whether or not possession has matured, right? So all of the persons who hold private land should be pushing for the move to the land registry system. And so move into case studies, and I think colleagues, you will find this very, very interesting. And I really commend these two cases to be read by any surveyor practicing in Guyana in title and by prescription through adverse possession. I believe that these decisions have been well thought out, well written, and it actually enriches the jurisprudence in Guyana, right? And the case is, first case that we will look at is the petition number 87 of 2002 in the Demerara Court, and this was unopposed, where Rajpati Loachi, the petitioner, petitioned the High Court, praying for title by prescription through adverse possession, parcel East Bank Demerara 857, shown as final plan number 58893 by TAK Fisher, sworn land surveyor, dated the 27th day of May, 2014. Now, the facts of the case is that parcel East Bank Demerara 857 is shown as lot number 41 on number 10045, dated 25th of September 1961, as the property of Guy Suku. And number 10045 was converted to a parcel plan and brought on the Land Registry Act by Section 37 in August 1977 by A. Earl, Commissioner of Lands and Surveys, as he then was. Hanan Loachi, a predecessor to the applicant, held transport in 2102 of 1965 for lot 14, now parcel East Bank Demerara 857. The petition was to the court. The petition to the court for registered land must be submitted. So this is the law concerning petitions, right? It must be submitted to the Registrar of Lands, and this is basically to cure a defect in the deed registry system. Under the deed registry system, a petition be made, and the Registrar of Deeds has no idea that that petition has been made, other than probably seeing it in the official gazette or the notices or something. The Land Registry Act cures that defect by requiring the application or the petition must be submitted to the Registrar of Lands so that a memorial can be made in the register, because on the Land Registry Act, the register is notice to the entire world of all of the transactions concerning that particular portion of land. So that is the law. So the petition was made under Section 1 of the Title to Land Prescription Limitation Act and Rule 3 of the Declaration of the Rules 302. And the Land Court has jurisdiction, obviously, to hear and determine all applications for registered and unregistered land. That's the registry land as well as land registry land. See, the application was made. So the court held that the application was made under the Land Registry Act, Chapter 502. And that cannot be the position. The law is that it must be transmitted through the Land Registry. It's not made under the Land Registry Act. A claim for adverse possession must be made under the Title to Land Prescription Elimination Act, and it must be made in pursuant of Rule 3 of the Declaration of Title Rules, made and affixed to 302 of the Laws of Guyana. So the court held that the court has no jurisdiction to make a declaration of title with respect to parcel 57, Block 8, Zone East Bank Demerara, since parcel 57 is not registered land under the Land Registry Act 42. And in obiter discussion, the court said that Section 37 only applies to the registration of grants of state land, right? So the analysis of this case is that the initial plan should have been a sketch plan. In all land registration areas, under the Act, the initial plan going before the court should be a sketch plan or an occupation plan as elucidated by the Lives Association in their presentation, and which is fully accepted, right? But the planning and the bylaws prohibit subdivision of residential lots and schemes. So Once it's a residential lot in an approved planning scheme, the division of that lot is prohibited by the local, by the bylaws and the planning laws. And therefore, this direction should be issued to site surveyors and the court. So if you're surveying land that is within a planning scheme that prohibits subdivision, well then obviously the person who is claiming adverse possession through prescription must demonstrate that they have control or possession over the entire portion of land. So this is something that should be looked at carefully. And since parcels 57 is held by a transport, the court has jurisdiction obviously to hear and determine all petitions for prescriptive title. Conceding but not admitting that parcel 57 is not registered land, the petition should be determined based on the merits. So the court can probably in orbital get into the very archaic discussion as regards to whether section 37 of the Land Registry Act could be invoked by the Commission of Lands and Surveys as it's clearly set out the literal interpretation of that provision, or whether or not the true intention of the act, which I agree with, is for areas to be designated in block and all of the titles in block perfected before moving on to another. I think that's the true intention, and that is what this case tries to bring out. But I believe that the jurisdiction of the court is to hear and determine all matters concerning prescriptive title, and the merits of the case should have been determined and the technical issue included as obiter, so that the peripheral issue on the class of registered land could have been elevated to the Chancellor and probably to Parliament for judicial review, because the only time you can basically change the words in a legislation is if it proves an absurdity. And section 37 is very clear. It touches on concerned public lands, and the Commission of Lands and Surveys, as TA Oral is authorized under section 37 to apply to the Registrar of Land to have government or state land registered and become registered land. And so that's an academic discussion that must go forward and must be elevated. And the second case is petition of the 7P, dated 29th of May 2002 in the Ireland Court, and this was opposed. And the proceedings was that Godfrey Best petitioned the High Court, praying for title by prescription through adverse possession of Track A Plantation Mosaic Canal, as shown on plan number 73105 by L.L. Rutherford, sworn land survey dated 7th of December 2018. The facts as established by the court is that the West Bank Estate owned Plantation Monzir by transport number 529 of 1927 and conveyed it to the Canal Pole Authority by transport number 451 of 1933. The petitioner, Mr. Best, and his predecessors were put in possession of the subject area in 1972 by the government of Guyana under the wrongful belief that the land was government land. And in 1989, they had occupied about 3 acres of Track A. In 1989, Mr. Best assumed control of the land and extended possession to the entire tract of land. And in 1989, Mr. Best applied for a lease. In 1998, Mr. Best applied for a lease on the 5th of March 2003. He accepted a grant of a lease from the government. The petitioner paid rent from 2000 to 2017 to the government, and NISL opposed. NISL the opposer, and the court held that NISL the opposer did not obtain title to Plantation Monzir by the transfer of property or the authority of 2017, since the earlier legal title in favor of the Canal Pole Authority prevails, right? So juxtapose this. This is what the court held, right? These are the facts established by the court, right? So later you juxtapose that with what the surveyor actually said on his land and how an ordinary person will interpret, right? So we come to that in a minute when we look at the master plan. So the law is that title to land by prescription through adverse possession may be acquired by sole and undisturbed possession, user, or enjoyment for not less than 12 years, without secret and without fraud, and without consent or agreement expressly made or given for that purpose, to the satisfaction of the courts. And this will obtain, you will not be able to obtain legal title if you cannot satisfy the court of all of foregoing, right? And this is subject to and except in cases of state land, government land, quasi-government land, statutory reserves, or any undivided interest in the aforementioned land. It shall not be acquired by prescription through adverse possession, except where, as elucidated in the very articulated case of in the land court, that the proceedings were pending before the court or possessory title had crystallized. And this is in the case of this, right? This is a pivotal case. So you can, if the proceedings were pending in court before 2011 or possessory title has crystallized, the court is saying that you can still acquire title by adverse possession. So this is a new definition of who can acquire. So the issues raised is whether the government and the state land may be acquired by prescription, and whether Tract A is government land, whether the petitioner and his predecessor were in sole and undisturbed user and enjoyment of Tract A, and from what date, whether the petitioner occupation of Tract A was with consent or agreement expressly made or given for that purpose, and whether the petitioner's adverse possession of Tract A, if at all, was for the relevant statutory period. And the court held that, very importantly, the government or state land may still be acquired by prescription if the petitioner's possessory title crystallizes before 2011. That the petitioner predecessors had occupied 25% of the prior to 1989 under a license from the government, and that he established use and enjoyment from 1989. That the government has superior rights to possession, right? So the government has superior rights to possession. So it exercises control and dominion over Tract A, despite being in the mistaken belief that it was the owner by the title. So this is from the Tulsi Prasad versus AG case, the mistaken belief principle. So the petitioner occupied Tract A as a tenant of the government from 2000, from when he first paid the rent, the use of the land, despite that the lease was issued in 2003. And very importantly, a person may be in possession of land, even if it is occupied by another. So the state is in possession, control and dominion, although it was occupied by Mr. Best, the petitioner. And the petitioner may be in adverse possession up to 2000, that is for 11 years when the lease commenced, right? So the analysis in this case is that the limitation period begins to run in favor of a tenant at will of private land, but not the state. And that is enunciated in section 9.1 of the Title to Land Prescription Limitation Act. So this is very important for people who own private property. The limitation period begins to run in favor of a tenant of private land, but not the state. A tenant at will is a person who is there at the will of the landlord under 1-year tenancy, and he begins to pay somebody else, or there's some confusion to be paid, but time starts run against his landlord who is probably living in another jurisdiction. The surveyor's statement at Memo 3 that no one attended the survey is misleading. And we touched on this issue already. If it is a survey for title to land prescription through adverse possession, the person who's making the claim must attend. And this is a point that has been very problematic for a lot of people using a surveyor's plan, right? The surveyor's report in this case is very vague and does not reflect the client's claim, because if you read the client affidavit, It talks about his grandmother. It talks about his commencement date, the type of occupation that they had, the trees and all these things. And nothing of this is reflected in the surveyor's report. So, I mean, a technician, as I said before, can go and turn angles and to pick up base and distance, but you must be able to distinguish yourself as a professional and sworn land surveyor to provide meaningful reports to the attorney and to the court, right? The surveyor positively asserts that the area surveyed is held under transport number 451 of 1933 by the Canal Pole Authority, while NISIL had a vesting order authority of 2017 for the land, and the court held that the government, through GLSC, had crystallized possessory title. And in all of the discussions in evidence and procedures for cadastral surveying, in that book, it elucidates the fact that a surveyor is a gatherer of the evidence for his client, for the court. And the determination of ownership of land is a matter of law. The determination of ownership of land is a matter of law. And that is why, if you go back to the suggested memorandum and report for a surveyor, the surveyor can say what his research is, but the surveyor should not and should shy away from making a positive statement asserting who owns land. And that is the distinction that must be made between the role of a surveyor, the role of attorney, and the role of a court. Because, as clearly stated in this case, the surveyor made a positive assertion that this area is held under transport number 451 of 1933 by the Canal Pole Authority. Going no further, if the court is to accept this and the attorney accept this and go forward, then the wrong transport would have been annotated, right? Leading to defective title. While NISIL was contending that they had obtained this land by order number 30, relying on an earlier transport, a 1925 transport, right? And then the court held, which is the absolute gravamen of the issue, determination of ownership of land resides with the court. And the court looked at transport number 451 of 1933, looked at the 1925 transport, looked at order number 30, and the court determined that that portion of land belongs to the government of Guyana, who has crystallized accessory rights, although they are not in actual occupation, but they are in control and domain over the land, right? So I hope that that point comes across very clearly to young attorneys, surveyors, as well as person practicing the title to land process, right? And very, very importantly, and this is a point that we must elucidate clearly and come on a very firm position, is that the surveyor does not satisfy the fundamental principles for a fixed boundary survey since it lacks retraceable cadastral ties. The survey for this particular portion of land, it lacks retraceable cadastral ties, right? The ties, if you go to the next slide, Danny, right? The next slide, Danny, slide number 35, quickly. Yeah, so this plan is the plan submitted by the surveyor. And if you look at it carefully, it says that 52 feet from the center line of this dam that runs north to south, there is a mark, and 2,365.12 feet from some other dam, there's a mark, right? This is not a cadastral grade tie, right? A GPS can probably put you close to this parcel of land if coordinates were on this plan. And this is the typical example of a contemporary cadastral plan that has been leading to original titles being granted. For example, if the court has agreed with Mr. Best and grant him title on this plan, then when the marks are removed, with all the development that is going on, when these marks are removed, there is nothing on this cadastral survey solid enough to lead you to another surveyor to retrace the original footsteps of this survey, because the center line is arbitrary, the distance is arbitrary. And if those marks are not on ground for you to retrace this tract, then you will start off as a position that is 2 feet away, 3 feet away, based on line of sight or the average of the retracing surveyor, which is totally unacceptable based on the fundamental principles that all lands that are privately held now came out of stock of state lands, and the principle of doing a cadastral survey that must be tied with bearings and distance of lands. And finally, when you look at this memorandum, right? The memorandum is also very, very vague. And it says that no one attended the survey. So this just shows you the standard of the cadastral plans that are currently being, so the client did not attend the survey, but so the surveyor was able to determine what the client is claiming, right? And colleagues, in conclusion, right? During a survey for title by prescription through adverse possession, user or agent, the professional land surveyor is a disinterested party gathering the evidence for his client and the court on the pain of perjury. The professional land surveyor may mediate and provide neutral advice to his client and the opposing end, and shall perform and execute the survey in keeping with the Surveyors Act and any other law touching and concerning the category of land affected. And he shall be prepared to corroborate the evidence at the request of the court. So that's the role of the surveyor. And the role of the attorney is to execute a title search of the property, assisting the court in ensuring that the grant to his client is a good title, right? So the role of the attorney is to execute a title search of the property and assist the court in ensuring that the grant, if issued to his client, is good title. And we explained that the grant issued to Mr. Best for the extension of VDA Road is issued on the transport for the second depth. And that is because the attorney failed to do his or her aspect of the title search to ensure that good title is issued. So for example, if somebody else has obtained a transport for that portion of land, then they will have two concurrent titles, and his title will be pointed to a second depth transport and the other person title pointing to the first depth transport, and that would be an interesting case. And the court is responsible for establishing and determining ownership of land. Since the ownership of land is a matter of law, the ownership of land is a matter of law outside of the jurisdiction of a surveyor, right? Whereas the boundaries are a matter of fact. Both must be determined by the court based on the evidence supplied by a professional land surveyor. And I thank you and open up for any questions. Over to you, Dan.
Mike, that was quite indeed an excellent presentation. I'm sure there's a lot of questions that are pending. I want to encourage us to submit those questions. I think the format, we haven't seen any in the chat, so I'm not sure if I missed any. But no, I don't see any. And so if there is, we can open the floor for some questions, 15 to 30 minutes. If someone is speaking, please raise your hand and we will try and facilitate those as they come in. So I see one coming in at chat. Let me raise it. Let me try and get this. Oh, wow. This is quite a long one. All right. Oh, this is Lou. All right, so Lou, why don't you go ahead then and raise this point? And I see two questions from our president. And yeah, over to you, Lou.
Good night, everyone. Can you hear me good, Donald?
Yes, go ahead, Lou. We can hear you.
All right, so it's two questions that I have. Let me just pull them up. The other one is more of soliciting comments, the last one. So the first one, so prescriptive rights laws and registry act requires a plan to be registered before the matter reaches the court for determination of granting of declaration of title by adverse possession. Right, Hutson indicated this earlier in his presentation. So the question is, what rule allows GLSC from refusing to record a plan done by a surveyor over any land reasonably claimed or otherwise, of which the court have to adjudicate and determine land rights and declaration of title? And as I mentioned before, this question is reference to Mr. Hutson's presentation. They stated only the court can adjudicate and determine rights of ownership to land. So I'm not sure if Ms. Hutson would like to address this one first, and then I can probably go on to the other one.
Yes, Danny. Please let me address that question first, right? So in the land registry area, designated land registry area, the original law required that all surveys, occupations starting with an occupation survey, shall be done by lands and surveyors. By an amendment of that provision in the Act in 1998, it allowed for private proprietors to employ surveyors to execute that occupation survey. Now, the occupation survey is not required to be registered lands and surveys as a plan. So, as I alluded to in the presentation, the declaration of title rules made and affixed to Section 302 of the High Court rules allows the court to even dispense with, on summary application by the petitioner, the requirement for a plan once they satisfy the other arm of the petition, which is to describe the land and so on, right? And so the law is that you're not required to register that plan, occupation plan, at lands and surveys. The surveyor has taken an oath when he's sworn a land surveyor to perform certain duties, and he can execute an occupation plan and give it to his client, and the court will use that plan, despite the fact that it's not being recorded at lands and surveys, as a part of the evidence in his petition to the court. So the short answer is that the occupation plan as required under the Registry Act as amended does not require that the plan be recorded as lands and surveys. By extension, the occupation plan signed by a surveyor without being recorded at lands and surveys could form a part of the petition in a claim for title to land by adverse possession for an application for registered or unregistered land under both Acts, 501 Land Registry Act or 502 Deed Registry Act. Danny?
Just a follow up to that one, to that same question. So under the Land Registry Act, I get that you can probably do the occupation plan and not register it. But under the Title Land Prescription and Limitation Act, you are required to register a plan. What happens in a case like that?
Title to Land Prescription and Limitation Act does not require a registered cadastral plan. All right? So there is no provision in the Title to Land Prescription and Limitation Act that requires a recorded plan. Right? You require the only provision in our laws that requires a recorded cadastral plan at the moment for the passage of title or for the award of title is under the Registry Act. So you will get a preliminary award on a sketch plan, and then you're required to record a final plan to obtain a certificate title. Under the deed registry system, you're not required to record a final plan, or under the Title to Land Prescription Limitation Act. You're not required. Because the High Court rules are very clear. The judge could dispense with the requirement of a plan on application by the petitioner summarily, right?
All right, guys,
Off to you,
I
Dan.
don't see any other question. Is there another question?
Yeah, so the second part of my question. So this other part is more of like a comment I'm soliciting. I know probably the commissioner will also wanna. If possession over land unrecognized act.
All right, I believe we may have lost you there, Lou. But if I may read it, if I may read the question, I would like to hear comments on this. If possession,
This amendment strengthens security of Kenya to the custodian of public lands only and says that possession is only an authentic root to title in and over private lands. Comments, please.
Could you repeat the question, Danny? Your
yes,
was breaking up.
yes, I can. In fact, it's in the chat, so I'll just read it again. If possession is an authentic root to title over land and recognizable under TLPL Act and the Land Registry Act, where the law says to the world that it is okay to obtain title by adverse possession over private land, thus recognizing the doctrine that possession is an authentic root to title, then why this doctrine was not taken in account during the 2011 amendment of TLP Act. This amendment strengthens security of tenure to the custodians of public lands only and says that possession is only an authentic root to title in and over private lands. He's asking for comments.
All right, so if I can go back as far as Cole versus Ramsburg, where our distinguished former judge of the Land Court and sworn land surveyor, Mr. G. Abrams, articulated very clearly that in most jurisdictions, particularly in the United States, right, possessory rights through prescription to federal and state lands are prohibited. So it's basically a strict prohibition. In Tulsi Prasad versus AG 2008, right, the question arose as to whether the state can be adverse, because at that time, the law was a private person could obtain possessory title after 30 years of possession, use, or enjoyment of state or government land. And that question arose in the court, and the court ruled that because a private person could acquire, the state could acquire as well. And so the case of Cole versus Ramsburg NDC basically set the foundation for the passage of the amendment to Section 3 of the Title to Land Prescription Limitation Act, where Just Brooms very persuasively argued that following the example of many jurisdictions, such as the United States, the state right to federal, state, and government land should not be trumped by adverse possession. And one of the pivotal arguments that he wrote was that every person has an undivided interest in public land, so to speak. And it is a rule of law that you cannot, or you should not be adverse to yourself, right? So he articulated the fact that reserves are set aside for the use of the public. And then why should a person with an interest in a reserve be allowed to acquire adverse possession? And he went further to say state and government land are basically public lands in which all subjects of the state has an undivided interest in. And why should they be adverse to themselves, right? And so I believe that there is good precedence for the case of restricting claims by prescription through adverse possession for public lands. But it's something that could form an academic discussion going forward. Danny.
All right, thank you, folks. Michael, thanks. We'll ask our president, Lou, to give a vote of thanks at this point. But before I hand it over to Lou, I want to encourage, I see we have a steady 50 participants going up to 51, 52. So we're very pleased and glad that all of you are here who joined us. We are especially very happy to have some of the legal persons joining us and being part of this discussion. We would encourage you, if you have thoughts on this, you can contact us at the association, and we'd be happy to, put your thoughts and suggestions to the group and have more discussions going forward. If you're not a member, we want to encourage you to become a member, and you're a surveyor, a practicing surveyor, we would like to encourage you to become a member of GAPS. And for those members that are here, we would want to encourage you that your fees or your dues are due. So please contact myself or anyone at Lands and Survey, Monifa or Mike, right there at Lands if you're there. And if you're overseas, we also have Kamal, and we've shared those contacts, his contacts, and how to get those fees paid for the year. So without further ado, Lou, over to you.
Good night again, everyone. To our guests and special invitees, I would like to say thank you for attending the presentation. Mr. Hutson, you have delivered a wonderful presentation. You have extended your knowledge to each and every one of us, including myself. I'm sure the young folks here enjoyed your presentation and had many takeaways. So I would like to thank you very much for taking time out to come and do this. Thank you.
All right, so thank you, Mr. President. Thanks to all those who attended, and we certainly look forward to your suggestions. We can improve this presentation and have it as a part of the toolkit for young surveyors going forward. Thanks a lot, and good evening to everybody.
All right, thank you, folks. Have a good evening. And just before you go, let me just also announce that the recording will be available on YouTube or on our website at gaps.gy.gov.